What's up, everybody? I'm back, and I'm continuing to go over everything that was being printed in the press at the time of Steven Avery and Brendan Dassey's arrest, everything that happened during the trial, and everything post-trial as well. We are currently post-trial. Both Brendan Dassey and Steven Avery have been convicted, and now we are looking at everything that has happened since their convictions. Today, we are starting back on September 10th, 2008, in an article from the Janesville Gazette, and of course, I will put everything up on the screen. Attorney demands crime lab investigation. Jerry Buting, the trial attorney for convicted killer Steven Avery, wants the State Department of Justice to look deeper into whether mistakes at a state crime lab played a role in putting Avery behind bars for life. Jerry Buting filed a complaint with the agency Tuesday demanding an investigation into the root causes of incidents that include an analyst who showed up to work drunk and fingerprint analysis who botched assignments. He demanded the results be made public. He said in the complaint the drunken analyst was working in the Madison crime lab. At the same time, analysts were working on scores of pieces of evidence in Steven Avery's case in 2006. He acknowledged he doesn't know whether the analyst played any role in Avery's case, but his or her presence could have contributed to contamination of evidence in that case. Justice Department spokesman Kevin St. John said in a statement the infractions were investigated, resulting in discipline. They took place before current Attorney General J.B. Van Hollen took office in January 2007, St. John said, but the agency would still review Buting's complaint to determine if any of his speculation has bias that merits additional follow-ups. The Associated Press reported in 2007 that 8 workers in state crime labs were disciplined between 2002 and 2006. This next article is from August 2009 and is from the Madison, Wisconsin State Journal. Man seeks new trial in 2005 killing of photographer. A young man convicted of killing a photographer in one of Wisconsin's most famous crimes falsely confessed, his attorneys said Tuesday, in documents seeking a new trial. In a motion filed Tuesday, Dassey's new attorneys contend that the then 16-year-old received ineffective counsel because his attorneys didn't offer substantial evidence against prosecutors' claims that his videotaped confession was reliable. Avery, 47, also seeking a new trial and has a September 28th hearing on that request. His new attorneys say Judge Patrick Willis refused to allow evidence that several other people, including Avery's 2 brothers, had motive and opportunity to kill Halbach. Willis has until December 1st to rule. Dassey's attorneys filed more than 1,000 pages of documents Tuesday saying that their client was a special education student and investigators' overwhelming tactics caused him to falsely confess. They contend that he received his facts, 19 of which were corroborated with physical evidence from different sources, including investigators, media reports, and family discussions. The documents say prosecutors failed to prove Dassey's statements were not a product of contamination, and that corroboration is reliable only if there were no contamination. One of Dassey's attorneys, Stephen Drizzen, described Dassey as a klutz who couldn't make a peanut butter and jelly sandwich without making a mess, yet noted that no physical evidence linked Dassey, who is now 19, to the crime. We believe that the jury in Brendan Dassey's case did not hear the whole story of how Brendan Dassey confessed, and that when they do hear the whole story, what they will see will lead them to conclude that the confession is not reliable, said Stephen Drizzen. Special Prosecutor Ken Kratz said he had not yet been able to read all of the filing. Until I see what exactly is being claimed, I am not going to make any intelligent comment on it, he said. No hearing on Dassey's motion has been scheduled according to court records. The next article is from September 2009 and it is from the Janesville Gazette. Steven Avery seeking new trial. Jury convicted him of killing photographer in 2005. A Manitowoc man convicted of killing a young photographer 4 years ago hoped to convince a judge Monday he deserves a new trial. Steven Avery believes it was unfair for a judge to deny him the right to identify others who might have had the motive and opportunity to kill Teresa Halbach. I don't understand. I mean, obviously, I am not any sort of expert on the Wisconsin legal system or anything in the United States whatsoever. But I don't understand why lawyers representing Steven Avery wouldn't have been, maybe someone can explain it to me, wouldn't have been able to offer up another suspect in the case. Why were they not allowed to present their case? Our client, I mean, I know their job is to prove Steven Avery isn't guilty. That's the defense lawyer's job. But wouldn't they have a better time doing that if they could, in their minds, prove someone else committed this crime? Being able to be like, Steven Avery didn't do it, and here's why. This person also had motive and such. So it's weird. I don't know why that's not allowed. I don't know how that works. Maybe someone can explain that to me. I would greatly appreciate it. Steven Avery's attorneys contend he was denied a fair trial in 2007 because Judge Patrick Willis refused to allow evidence that several other people were possible suspects in the murder. The same judge is presiding over the motion. Imagine, this judge is expected to be like, yeah, I was wrong in 2007. Let's go. Let's redo the whole thing. He's not going to overturn his own decision. Is that a thing? Is that a thing that happens? Do judges often or ever overturn their own decisions? I would like to know. Is that a thing? Like, show me, I'm going to look it up after this, but if you know of anything offhand of where, like, a judge made a decision in 2007 and now 4 years later he's going to be like, I was wrong, let's do this again. And I don't see that being very common, but maybe I'm wrong. A jury convicted Steven Avery of first-degree intentional homicide and being felon in possession of a firearm. His nephew Brendan Dassey was later convicted in the murder as well. DNA evidence played a major role in Avery's conviction. A DNA analyst at the state crime lab who had helped clear Avery of the sexual assault charges in 2003 testified that she found Halbach's DNA on a bullet discovered in Avery's garage that was linked to a rifle Avery had hanging on his wall. Also, Halbach's vehicle key was found in Steven Avery's bedroom with a trace of DNA on it. The defense argued that someone else killed Halbach and police then framed Avery by planting his blood in her vehicle and putting her key in his house. The jury was not convinced. Defense attorneys could have put forth a stronger case, but were hamstrung by a pretrial ruling that limited the evidence they could produce according to court documents they filed in June in support of a new trial. He was prevented from advancing a key claim in defending himself against state charges that other individuals were responsible for Teresa Halbach's death. At least 4 people had the motive and opportunity to kill Teresa Halbach and frame Steven Avery, the then boyfriend of Steven Avery's sister, Avery's 2 brothers, and his nephew, the documents state. The then boyfriend and nephew might have accused Avery to cover up their own guilt, the documents said. Avery's brothers might have been angry he was joining their family salvage business, knocking their shares down from 1/2 to 1/3. The judge's pretrial ruling had been based on precedent set in a 1984 case. In those proceedings, a homicide suspect wanted to call a witness. He had the motive and opportunity to commit the crime. The judge denied the request in part to prevent an irrelevant parade of witnesses that could distract from the evidence. So the judge, I guess that answered my question, but that is stupid. The judge didn't have to go by this precedent. The judge could have been like, maybe someone else did have motive, and maybe we should hear all sides of the story. He could have, even at the very least, limited the amount of people that they could accuse. Like, they listed 4. That doesn't seem like an unreasonable amount of people to have to talk to. Sure, if they're going to be like 100 people had reason to commit this murder, that's pretty ridiculous. But they only listed 4. So I feel like the judge should be like, I feel like that should have been allowed. But the ruling shouldn't have applied to Avery because he only had a handful of suspects to challenge, each with a realistic motive. Man, I really need to read these. I'd never read these ahead of time. I love how it's like answering my own question. I like read a paragraph and then I get the answer in the next one. I should read ahead. The trial court's rulings deprived Mr. Avery of his constitutional right to present a defense, the filing said. So those are the ones we're going to go over today. A couple people showed up drunk at the state crime lab. The judge didn't allow Steven Avery's attorneys to state that other people could have committed this crime. I believe this was covered in Making a Murderer, if I remember correctly. I don't know how much they went into it, but I remember hearing it somewhere before. But yeah, it's weird. Like I said, I totally understand if his attorneys were like, we have 100 people that could have committed this murder, that's a bit unrealistic. But they had 4. That does not seem like an unreasonable amount of people to look into. Feels like they were just like, oh, it could have got Steven Avery off possibly, and maybe that's what obviously they didn't want to happen. So they were like, no, we are not looking at these 4 people. The jury will never hear about these 4 people, I guess. And they will have to focus just solely on Steven Avery, and that played a part in his conviction. It seems like it. Like if the jury was given 4 other people that could have possibly done this crime, Steven Avery may not be sitting in prison to this day. Just some food for thought. What do you think? Leave some comments below. I hope you're having a good day, and I will see you again soon.